What's up everybody, welcome to Money Management channel. My name is Andrei and today I'm gonna be doing an update on MMTLP and FINRA saga.
I got the cash in the bag, stadium packed, born a rock star in this life, gonna live it up.
And in today's video I will show you the latest news directly related to this story. I will show you the updates from Richard Hofman. I will show you new articles and new potential lawsuits that might be filed in just several days or weeks. And before we dive deep into this news, please hit the like button, subscribe to my channel, share this video with your friends and family. This will help us to fight together against illegal activity of fraudulent hedge funds and some authorities. And this will help us to win this battle. So, let's start with Richard Hofman's Twitter account. And for those of you who don't know, he one of three persons who filed lawsuits against authorities and fraudulent hedge funds, and his particular lawsuit directly related to Fidelity, FINRA and DTCC. And I have to say that if you want to know more and if you want to know his latest updates, and I have to say that he's doing an amazing work, he published updates quite often, and that is why if you want to follow the latest updates directly related to his lawsuit, I highly recommend you to follow his Twitter account and subscribe to his YouTube channel. And his YouTube channel is right here, Not Legal Advice, KNOT. And I have to say that he published an update. Recently he published an update and his latest update on YouTube channel is following. FINRA mandatory arbitration for all investors is yucky. And it is quite a long video, almost 20 minutes. And in this video he describes the main difference in between arbitration and lawsuits. And definitely all of these options have their pros and cons, and to summarize it all, I have to say that arbitration is quite good in terms of a time, because usually the decision can be made in a shorter period of time compared to the court. At the same time, it is much cheaper for both sides to use arbitration instead of court, but on the other hand, we have a lot of limitations, and one of the main is that usually in arbitration the settlements and the amounts of payments for settlements are less compared to the court's decisions. And definitely it is not the best choice for the customers of a particular broker-dealer, because it might be a conflict of interest. And Richard perfectly described this situation. Let me show you that if you sign a contract with any type of broker-dealers, and this is one of the examples, you cannot deny the bullet point that is directly related to arbitration. And you have to use arbitration instead of the court. And let me show you that you can find this information. All parties to this agreement are giving up the right to sue each other in court, including the right to a trial by jury, except as provided by rules of arbitration forum in which a claim is filed. And you cannot basically deny this rule, and you have to use arbitration in any type of disputes. But think of it like this. If you're a big firm, big brokerage company like Fidelity, for example, you have to deal with multiple disputes, and definitely you have some kind of contracts with arbitration, with a particular arbitration, and this arbitration firm might be extremely dependent on your contract, and that's why they can make decisions in your favor. And definitely it is a conflict of interests. And I have to say that I will put all the links in these documents, so you can read all the letters and you can read all the limitations, how you can or cannot be in arbitration, and what should you do if you want to avoid this type of resolution. And definitely I have to say that the only reason that might work for 100% is the class lawsuits, and you can also read it right here. So let me show you that we are about to see more lawsuits, and right now we are on Twitter account of Mark R. Basil Esquire, and He is head of Securities and Public Company Restructuring SPAC attorney, representing public companies in complex financial litigation in federal courts around the country. And let me quote you his recent tweets. MMTLP OTC lawyers, we are now investigating a major potential RICO action. Stay tuned. And he also added 5 hours ago, MMTLP, just remember, civil RICO damages are tripled. This means if they will file another lawsuit, and definitely they have all the possibilities to win this lawsuit. And if they will win it, definitely all the MMTLP shareholders will have potentially tripled of the settlement that might be on an ordinary case. And I have to say that definitely right now time is working on us, because we have amazing people who are working on this process. We have 3 lawsuits, and probably we have even more, but we don't know yet about them. And we have a lot of updates from, for example, awesome person Richard Hofman. I'm for 100% sure that his case is one of the best right now in terms of information to the community. And I have to say that if you don't know how big the problem is, I highly suggest you to read this article that was published just a couple of days ago on Investor Turf, and it says The Anatomy of Short Attack. And the subtitle is Abusive shorting is not the result of random acts by rogue hedge funds, but of a coordinated business plan carried out by a collusive consortium of hedge funds and prime brokers. And let me show you this picture that, in my opinion, is extremely well drawn. So as you can see, on the peak you can find, you can read targeted company, and all of the wolves around this table are following Senate Banking Committee, SEC and FINRA, big bank dealers, Depository Trust and Cleaning Corporation, paid bashers and liars, placement double dealers, fake lawsuits, and they are waiting to eat this targeted company. And definitely it is, in my opinion, extremely well drawn picture related to our situation. So let me show you another quite good news. We can find this article, this press release on prnewswire.com, and it is related to the Robinhood. And let me quote you this. On April the 10th, you can find that Clafter Lesser LLP, a highly experienced class action law firm, announces that it has filed a class action lawsuit together with Pesach Law Group PC and Sharon Law Firm in the United States District Court for the Central District of California, seeking to represent investors who held call options on the Robinhood trading platform as of close on January 27, 2021. To purchase any of the following stocks. It is related to AMC, BBBY, BlackBerry, GameStop, Nokia, and others. And what this case is about. The lawsuit alleges that on January 28, 2021, Robinhood Markets and 2 of its wholly owned subsidiaries prohibited purchases of the stock underlying the affected options on its platform, and also prohibited purchases of the exercise of the affected options, and thereby only allowed the closing out of such positions. So they just turned off the buy button, and this was the real damage for a retail community, because none of them were able to buy these shares, and this means a lot of fraudulent hedge funds who shorted these stocks saved a lot of money because of that, and people who wanted to buy these shares and who wanted to short squeeze these fraudulent companies even more, they lose their money. And I have to say that these type of lawsuits are not directly related to MMTLP and its saga with FINRA, but in general we have the problem that is much bigger than the MMTLP and FINRA battle. We have a lot of companies that daily might be short targeted and that might file even a bankruptcy in a short period of time, and definitely it is hurting the entire economy, and we have to fight together in order to win this battle. And to do so, I highly recommend you to subscribe to my channel, hit notification bell, hit the like button, and share this video with your friends and family. and this will help us to win this battle. See you guys and girls next time. Bye!
I got the cash in the bag, stadium packed. Born a rock star in this life, gonna live it up on the attack. Baby, I'm bad, I just